Aloha, and I'd like to welcome my two guests, Louis Chang. Welcome, Louis.
Thank you.
And Chuck Crumpton.
Hello.
Chuck.
What are the rules that the realtors work under?
The term realtor refers to a person that's a member of the National Association of Real Estate.
Okay.
So it's a membership thing. Not all real estate agents are realtors. But when you say that this individual is a realtor, meaning a member of the National Association, they have a code of ethics that they are obligated to perform under. The state also has licensing provisions that include regulations of what is proper and improper broker practice. So those are probably the primary stated rules. Then there's, I guess, general principles of fair dealing, honest dealing, and the like.
When a realtor and a client enter into an arrangement, what is the relationship that's created?
There is a realtor-client relationship. There are professional duties that apply. A number of those, as Lou correctly indicates, are set out by the association. A number of others are set out by law if they enter into transactions. It's different for sellers than for buyers. Sellers usually have written listing and sales agreements, and those have all kinds of special provisions to them. Often buyers do not, but they're represented by realtors. Once there is a purchase offer and a purchase agreement, as part of that, both the sellers and the buyer's realtors will be part of that written agreement, and their commissions will be part of it. But the duties usually come from the transaction. If they're representing somebody in the transaction, they do, as Lou indicates, have ethical duties, and they also have legal duties and standards of care and things like that, like doctors and lawyers.
What's the difference between a realtor and a broker?
A broker is an experienced real estate agent that has taken an additional licensing examination step to establish that they've been in the business a certain number of years and they have a certain degree of knowledge sufficient to pass a broker's test. It allows that person then to do more than a real estate agent.
Are many brokers principals in their firms? Not all, of course, but
you need to be a broker to run or manage a firm. And I think that you don't have to be a broker to be part of a firm. It just means that you're more experienced and have a higher licensing status. You could set up and run an independent company as a broker, which you could not do as a real estate agent.
Now you got buyer and you got seller. Does each of them have to have a separate realtor?
Buyer and seller each should have an independent real estate agent. There is an overly common temptation and tendency of some real estate agents to try to be an agent for both buyer and seller. In theory, that is possible. In practice, it is difficult because it creates a lot of difficult to resolve conflicts when a real estate agent usually should have a fiduciary duty to that agent's client. But when an agent attempts to serve two masters, you run into the difficulty of how can you fairly represent both sides who have some naturally conflicting interests. One wants to pay less, one wants to sell it for more, faster, slower, terms and things. They have different interests, and it alters the relationship of the real estate agent who serves as what they call a dual agent.
A dual agent, okay.
Like I say, it's common, it's difficult, it's not advisable, and it leads oftentimes to increased problems.
Problems, yeah. Okay.
And in this state also, not necessarily in all states, but in Hawaii, a dual agent is required to disclose that to both parties and also to obtain a written agreement to the dual agency.
Also, there's a written agreement that has to be signed off on by both parties.
Usually that would be the
Okay.
ethical standard.
Okay, okay. So thank you.
Most leases here are longer than that.
Mm-hmm.
6 months is kind of standard. A year is used frequently. I've seen a few shorter than that. Once it's up, you can go to a month-to-month if you don't renew, or you can renew.
Mm-hmm.
A 30-day is basically a month-to-month.
Okay.
And so there are certain legal standards that apply to that in terms of how much notice the tenant has to give to terminate, how much notice the landlord has to give to terminate. And there are different time tables for
Mm-hmm.
that, depending on whether the reason is non-payment of rent, or they just want to move, or the landlord wants to rent it to somebody else or sell it, or take
Mhm.
it back for themselves. So these are things that aren't frequently spelled out in the green form rental agreement that many realtors here
Yeah.
use. There are some legal provisions for that. For example, if there's a problem with the unit, a health or safety problem, there are situations in which the tenant can withhold rent, deposit it in a rent trust fund,
Okay.
and have the court determine what the appropriate cost of remedial measures is, and
Mhm.
maybe apply some of that rent trust fund for that. In a non-payment situation, the landlord may go for summary possession, which is a legal term that means they try and get the place back quickly and then figure out how much is owed for back rent
Mhm.
later on. If there is a fight over whether the landlord really does have the ownership right to lease out the property, that may go up to either a higher court or a more involved proceeding, and may not go the kind of speedy route if the landlord can show clear title and either non-payment by the tenant or some other kind of breach by the tenant,
Mhm.
damage to the property, violation of house rules, health or safety infractions, something like that.
Can the landlord use the security deposit for whatever he wants if the tenant is in violation, or is he limited, or what does he have to do?
No, he can't. There are legal limits on that. There's a temptation on the part of landlords who don't take time to know the landlord-tenant code to think, well, if the guy doesn't pay the rent for this month, I'll just apply a security deposit and make him put in another deposit. The law does not allow that. If you get to the end of a rental period,
Mhm.
and the landlord says, well, I want to withhold because I've got a cleaning fee and there's some damage to repair, and besides, I think it's time to change the carpets and maybe repaint and stuff like that.
Yeah.
There are certain things that the law may allow the landlord to do, certain things that are not allowed, but the landlord does have to provide notice of those and opportunity for the tenant to contest them. And it could wind up in court if they're not in agreement on that.
Wow, okay.
And landlords who forget to provide inventories of what's in the unit at the beginning can have a problem later on trying to establish that something was lost or taken or damaged.
Okay.
The landlord-tenant code actually requires the landlord to give a written explanation of any claimed right to use a security deposit. And if it's going to cover damages and the like, to have actual estimates or receipts for work done to back it up, and that has to be done, I think, within 2 weeks or 14 days in writing. Otherwise, the court will be very strict in favor of the tenant if the landlord doesn't comply very precisely with the timing requirement and what's to be produced. Courts generally will rule in favor of the tenant.
Wow.
There are a couple of ways to do it. There's a non-judicial way to foreclose, and Hawaii has recently implemented some new laws that make that very unattractive for lenders. And most lenders now, including Fannie Mae, on a policy basis, are saying no more non-judicial foreclosures, stop the existing ones, and go all judicial.
Oh, is that right?
Second, in addition to that, title companies probably are not going to issue title to non-judicial foreclosure buyers anymore, particularly banks who take back property by non-judicial foreclosure, because there are a lot of conditions in that new law that have to be met, and the title companies are not going to take the risk that those have been met. So the likelihood that there will continue to be many non-judicial foreclosures here in Hawaii is very small. So the program that's set up for non-judicial foreclosure mediation may be a nice fallback, but probably won't have much occasion to be used.
Wow.
Instead, you're going to see a lot more judicial foreclosures, which require filings in court, notice, and process servers to deliver notice to the occupant of the place, as was done here. But we don't have a mediation program in place for that. We are proposing one to the courts. We're working with the courts on developing one that would involve community mediation services and low-cost evaluations of foreclosures in order to figure out, one, is there a problem with the mortgage? Is there something that the bank did wrong? Did they not disclose something? Did they not provide something? Did they do something wrong that might make the mortgage not enforceable in court? First question. If there isn't, then it goes to the second question: does the owner qualify for loan modification? Because there are standards for that out there. They're kind of discretionary with the lenders, but that's the question. Second question after that, if it looks like the owner might, is does the lender have an effective loan modification program that is adequately and consistently staffed? And quite frankly, many of them, maybe most of them, do not.
Do not.
So they are not ready to deal with loan modification on a national or even a local level.
Wow.
In most of our experience. One of the federal judges anticipated this set of problems as mortgage suits came into federal court and set up what doctors call a triage program, like you do in MASH. Figure out what's the injury, what's the diagnosis, and what's the fastest solution. If the borrower may qualify for loan modification, then you can use a mediator to help work that out.
Oh, okay.
If they do not, then the mediator may help them look at other alternatives, such as, should the borrower just give the property back to the lender, called a deed in lieu of foreclosure, instead of having to go through all that legal process?
Oh, there is that. Okay.
Another way to do it is what they call a short sale, which is take a limited period of time, sell it for the best price you can get for it. If it's short of what it would take to pay off the lender in full, they're still done and they walk away. Third would be, if the property looks like it might have enough value to satisfy the lender, they might want to modify that, take a longer period, dismiss the foreclosure suit, try to get a fair market sale of the property and see if that comes close to paying off the lender. And in fact, if the sale price pays off the lender and has excess proceeds, then the borrower would get something back.
And that is to look for a experienced, qualified real estate agent that handles foreclosure properties, distress sales, short sales.
Oh, there are specialists in that particular area.
And they should find someone who has clear experience in that. Not every agent has that skill or experience, and they ought to make sure they have an agent that represents only them.
Okay.
And Lou raises an extremely important point, and that is that both borrowers who are in distress, behind on their mortgage, or in problems on their mortgage, there are loan modification groups out there, and they are very, very reputable. And so the Legal Aid Society of Hawaii assists with that. They know of some of the others. It's a good place to start. There are also some out there that are not so reputable, and you need to be careful. So start with somebody that's reliable. The second thing is, there are groups out there, I've heard of some that represent themselves to be mortgage auditors, who offer to provide services to borrowers to analyze whether they think there is some problem in the legality of the mortgage. Some of these groups that I've heard about recommend to buyers that they fight the mortgage or stop paying the mortgage because they claim that there's a problem with it. Sometimes they may be right, sometimes they may not be, but these are not groups who are authorized to practice law, as far as I understand. They're representing themselves to be mortgage auditors, and they're part of the problem as well.
Wow, wow.
So it's become a really messy situation.
It sure has.
And the first thing to do, whether you're a renter tenant or whether you're a borrower on a mortgage, is find someone reliable, whether it's an attorney or a real estate agent who's experienced in this area, who is exactly right, that can guide you through this mess and help you understand what your choices are.
What about the realtor or the real estate agent who rents a property, and it comes down to it that it's subject to foreclosure? Do they have any risk in terms of liability?
The real estate agent may have some exposure, but probably not significant, because if the agent searched some available data sources for available properties to rent, and representing the tenant went to rent it, you wouldn't expect the real estate agent to know the financial details of the landlord.
Okay.
However, if there was a foreclosure lawsuit filed, and usually the lender will then record what's called a notice of pendency of action. That's kind of a recorded land system notice to the world that there's a lawsuit out there to foreclose a mortgage. If the realtor didn't bother to run a court check and find that out, that's not a settled point of Hawaii law as to whether a realtor in a rental situation has a duty to do that. As a mediator for 26 years and Lou for even longer, that would not be a comfortable position for a realtor to be in. It might well be construed to be a duty, and if they're in breach of it, they could have liability problems.
Are they individually liable, or is it the firm that they represent?
Both.
Both. Okay.
If the transaction is on behalf of the firm and the firm receives part of the commission or payment, as Lou indicates, the firm is in there as well.
There's a practicality issue here. I mean, from the Joneses' perspective as tenants, how injured are they? And if they haven't suffered significant financial injury, there's not going to be the practical need to pursue the real estate agent.
Unless emotions get involved, right? Like we've talked about it. Pain, anger, and denial.
But you still need to be practical about it.
Sure,
in terms of
absolutely, and let's hope they are.
Spending money to get some positive result rather than negative.
But Leo, you make a really good point, because one of the reasons that Lou and I are in business as mediators and probably have more business than we could actually take is that emotions do get involved. When people are treated in ways that they consider to be less than respectful, less than fair, less than honest, they will react. And they will attach monetary value to their upset that the legal system may not. And they may pursue it and go see a lawyer and try and go after things like punitive damages and things like that. And they may legally escalate the conflict to try and match their level of emotional investment. Although our legal system is probably not going to reward that monetarily.
Well, with that, we'll see what happens to the Joneses.
But there are attorneys who will take that.
I understood. Well, I'd like to thank you both. Chuck, thank you as always. Sorry for the sweaty hands. It's a little hot in here. Lou, thank you as well. And welcome back to Hawaii, Chuck. So
thanks.
Nice to see you here. And Lou, thanks so much.
Thank you, Leo.
Okay. And aloha and goodbye.